left-hand side, there's always 6 witnesses. You have the 3 for the plaintiff or prosecution, 3 for the defense, and then across the top you put plaintiff or prosecution and defense. And then in each square you write, what are the key things you want out of this witness? Why is this witness here? Why is it important to the case? A few key words drawn from that witness's testimony. And those are the things that the party presenting that witness is going to want to get in, or the party cross-examining is going to want to either keep out or show contradictions or impeachment or something like that. But from that, once you do that chart, you should get a good idea of what the theme for your case is going to be, and the other side too. And it's important for both sides to go into a trial knowing not only what their theme of the case is, but what the other side's probable theme of the case is, or several themes. And a good way to get these themes, I presume in literature classes you still teach mythology, Shakespeare, whatever. This is where the classical themes come from that arise over and over in lawsuits, and we use that. Very often they're biblical themes even. And if you can work that into your case, that makes it ever so much more memorable and believable, because the jury or performance judges have something that they can relate to. I've also judged at the national level, and some of the best examples come from there. One year we were in Nashville, Tennessee, and the theme of the case, the case was about Elvis Presley. He died in, whatever it was, 78, 79, of an overdose of drugs, and they ruled it was self-inflicted, and that was the end of it. But our case, the facts that they brought in was some member of Elvis's entourage came forward and said it wasn't an accident, it wasn't something Elvis did to himself. There was somebody in the entourage who wanted to kill him, and he slipped him these extra drugs that, mixed with what he was taking, killed him. So they brought a murder prosecution, and that's what the case was about. The defense was that the guy who slipped him these drugs didn't mean for Elvis to get those. He was going to take them himself because he was so distraught about, he was about to be kicked out of the entourage, and he was going to commit suicide. So it was an accident, and he wasn't responsible. The attorney, the student playing the attorney for the prosecution, in closing argument began, to be or not to be. That was the question facing this defendant. And just as in the play, this defendant chose to kill the king of rock and roll, obviously. And that just blew us away. That was a 10 closing in our book. Other things I've seen were, some years ago there was a case here in Wisconsin where one of the characters' names was Baba O'Reilly. And if you remember the song by The Who, you know where that came from. But I wasn't sure whether the students remembered that or knew that. And I had leaned over to my performance judge and said, do you think these kids know where that comes from? And the next question that the student playing the attorney asked was, isn't it true that this school was nothing but a teenage wasteland? So right then and there, I knew he did know, and I thanked him for bridging the generation gap. So anyway, that's all I have, and I'm willing to take your questions. And
I've got 5 more minutes before I have to leave, so questions to either one of us? Mm-hmm. Sir, wait for the microphone. I think it's going to work better. Right up here, Marcia. Right. Second row middle.
Judge Crocker, I think it'd be helpful, particularly for the teacher coaches, for you to speak a little bit from the perspective of the presiding judge as to the differences. There are subtle differences between the mock trial rules of evidence and the rules of evidence that lawyers and judges use every day, and I think that can be lost a little bit on the students. in terms of realizing how they should educate the judges when they have an objection?
Sure. That's a very nuanced question, and it's true. The difficulty that the students are going to have is persuading a presiding judge that the rules are different from what the presiding judge thinks. And it's kind of like we were just saying, that some of these presiding judges are lawyers in real life, and they really like being the presiding judge. So from their perspective, their knowledge of the way the rules work is the right way. I can't point to a specific example now about what rules are different from the real rules, but I know in the actual rules of evidence that are presented in the materials, there are annotations that show that this is different. The only thing that I can suggest that would be useful during a competition, if a student runs into a problem like that, is to have the page number ready of the materials, to have the book handy and point the judge to the page. And when I say the student, actually it would be one of his or her colleagues back at the table frantically paging through it, because it's not something you would expect. But there's really no substitute for having your book handy and having it marked. Where are the rules? Where are the rules of the competition? Sometimes that's going to come up, and of course nobody expects that either. And if you want to talk about rules the judges don't understand, it's more likely going to be the rules of the competition than the rules of evidence. And so the only way to persuade a judge, particularly one who hasn't read them very carefully, if he or she has read them at all, that you're correct, is to put them on the page and let them read the rule themselves. And I don't think there's any better way to do it, because it's hard for me to envision somebody with a black robe on being persuaded by a high school kid that kid knows the rules better than he or she does. So that's the best I can give you. Other questions? Way in the back.
A twist on the reality. You know, in the real world, when the judge says objection sustained, and you're the questioner, you say, all right, is there another way I can try to do this? So you try route 2, and the judge says objection sustained, and you try route 3, and that works. Now, in the mock competition, are there deductions because once the judge has ruled, they try to do it through route 2 or route 3? Or the judge say, listen, you aren't listening to me.
Certainly, and there are so many variations on that observation where the students either don't understand what the judge is trying to tell them, or they've got a script and they're going to stick to the script even though the judge has just knocked out that entire line of questioning with his or her ruling. And again, the two things the students have to keep in mind as lawyers is, one, be on top of your game, be ready to extemporize. 2, understand what the judge is telling you, and if you don't understand, ask for clarification. Certainly that's not going to result in point deductions, and it might actually result in a point increase if a student were to ask an intelligent question asking for clarification of the ruling. One other point that I think you all should be aware of, and you probably are, is that the whole objection process in mock trial is very different from real life. I call it the O3R rule: objection, response, reply, ruling. In real life, more often than not, the judge is just going to rule the minute the objection is made without asking for explanation from anyone. And some judges in real life will do that. Or I'm sorry, some judges in mock trial will do that because that's what they're used to. And the students will have to diplomatically remind the judge that everybody has an opportunity to explain things, because even if you lose the objection, your ability to articulate the reason for it lucidly is going to score you points, and the team is entitled to the opportunity to do that. It doesn't happen often, but it does happen occasionally.
Yeah. There's also something to be said for tenacity. If there's really something that they need to get in and a judge rules against them once, but they can think of some other way to get it in, and they do, that's going to count in their favor, I think, as far as the performance judges are concerned. And Judge Crocker is right. The judges are used to just hearing the objection and ruling on it, and then after the jury's gone, they'll maybe have a conference with the attorneys and make a record or something later on. But here, we have to make the record right away. I remember one judge in Milwaukee who always reminded attorneys, before you argue in front of the jury, you've got to ask my permission. So an attorney made an objection, the judge overruled it. He said, may I make an argument? He said, no. Not in front of the jury, anyway. You can make it later. But here, of course, you're going to do it in front of the performance judges, and that's one of the things we're looking for, is the coherence and accuracy of your arguments on the objections, as well as the grounds for the objection itself.
And one final point on that, and we were discussing this a bit before the presentation, is that you can also teach your lawyers to make an offer of proof. Whether the judge accepts it or not is up to the judge. But in a case years ago, maybe a decade ago, there was a kidnapping and murder of a small child, and one of the witnesses had nothing but hearsay to offer. And if the objection were made and sustained, that witness had nothing to say. Well, how do you score that? You've lost an opportunity for a direct, for a cross, and for a witness. And I don't know when that scenario was put together that the writers actually had thought that through sufficiently. I don't think that one was on purpose. Sometimes there are landmines put in there on purpose. But what we would do then, if the students hadn't thought of it on their own, was to ask them if they wished to make an offer of proof outside the presence of the jury. And then we did it as if it were the direct and the cross, and the witness got to testify, and they all got their scores, even though, as a technical matter, the judge had sustained the properly made objection. Now, hopefully, we're never going to see that again. It's like Halley's Comet, not in our lifetime. But again, there's really no substitute for being able to think on your feet about those kinds of things.
Is there an in-service for judges before the tournament begins? And I'm thinking in particular about two different issues that you raised. You talked about the fact that sometimes judges don't remember that attorneys are entitled to argue the objection. And also you mentioned very early on about low-scoring judges. And I mean, I think an in-service should at the very least remind them that this is a critical tiebreaker, and one outlier can totally wipe out a deserving team just because their theory is to start at 5.
Oh, I agree 100%. That's one reason I dropped out of coaching. I was breaking too many pencils in the back row because, of course, as a coach, you always think you know better than the judge who's making those stupid rulings against your team. And you're probably right, but the point is you're stuck with it. To answer the question you actually asked, yes, there's the equivalent of an in-service, but it's very brief. It's an honor system. I think the bar is hoping and assuming that if a lawyer is interested enough to volunteer, that he or she will actually read the materials. And that's where experience comes in. But let's face it, in some districts, they're scrambling for judges 2 days before the competition because they didn't have enough people. And people are in there because their partner said, listen, I really need a favor. Well, what are you going to do about that? It's not a good situation. It doesn't happen often. But I would say, as somebody who's been on both sides